Good afternoon, guys, and welcome again to this Saturday afternoon of the Law and You. Today's edition is brought to you once again by Washington Law Firm, located at 455 Utica Avenue, Brooklyn, New York. As I get through today's edition of the Law and You, I encourage you guys to press the like button and to share this video so that people who need to hear this content will be able to hear it. It will reach the right audience. So I encourage you to share this with your friends, your family, your neighbors, whoever you might have that you know this content will be helpful to. I encourage you to share it because it's your help that helps me to continue this program of bringing you the Law and You every Saturday at 4 p.m. So today, guys, we're going to be speaking about a trust versus a life estate. So for those of you who have real property and sometimes you want to know what is best for you to do, let's get into it today. We'll be dealing with a life estate versus a trust. Let's start with a life estate, because if you look back at some of my videos, you will see that I've dealt with a trust in the past, a revocable and irrevocable living trust. So let's talk a little bit today about what is a life estate and who should get a life estate. Now, a life estate is exactly what it says. You get an estate until you die. So at the time of death, whoever you choose that the remainder estate should pass down through, that remainder interest continues to the person who you wanted to inherit the remainder interest in your real property. A life estate is more akin to real versus personal property. So when we talk in the context of life estate, think about real property. And in this context, we're not speaking about those people who have like billions of dollars in real estate. We're speaking about one of the smaller real estate owner, like for instance, a person who might own maybe one or two real properties somewhere in the state of New York. And you're thinking to yourself, what should you do with that estate? Now, one of the reasons a life estate is encouraged is for those people who might end up taking social services in the state in which they're living in. They might need to get long-term care in a nursing home facility, or they might be prone to some sort of chronic illness and they have no way of dealing with it. And the possibility of that person ending up in a nursing home is a very, very high likelihood. So in order to preserve your assets for your loved ones or the people that you're going to be leaving behind, sometimes it's advisable that you create what is called a life estate. There are cases where where people are afraid or they're fearful that if they do take a life estate, they're concerned. That's one of the reasons why people do not transfer their real property to their children, because some children will actually turn around and sell that property with you in it. Case on point, once a person who wasn't my client, but they were a client of an attorney who I once was friends with, and the attorney did assist that client in transferring his assets to the mother of his child so that the child would inherit when the child become 18. Unfortunately for that man, the attorney who did the transaction did not secure a life estate for him. And when that child became 19, I actually ended up being the one to represent that child. He was in the process of selling the property, even with his father in there, so that he can have that money, that assets. Because once he turned 18, he told his mom, listen, I would like you to transfer back this property. I would like you to transfer this property to me so I can sell it. And the mother did exactly that. And while his father was still living in that property, he was attempting a sale. The father went and hired an attorney. Ultimately, the outcome was not that great for that father. The property ended up being sold. And fortunately, he got an interest in his own property that he was entitled to live in until death. So this is why some parents are very hesitant, because you make your child, but unfortunately, you don't make the mind of that person. And not everybody has the willpower to be a person we would consider good. Some people are just not well connected to moralities and the things that the normal person would consider good. So they choose a path which they believe to be right. Therefore, it's never advisable that a parent take a property in which they're living, or a property that they intend to spend their entire life in, and transfer that property to a child. Therefore, there are options. And what are those options available to you? The first one is, for a very small estate, is a life interest in the real property. Now, if you intend to do a life interest, what happened is the deed is restricted. There's a restriction on the deed which states that the grantor, which is the parent who is giving the property to the child, retains a life estate in that property. That would therefore make it impossible for the child to transfer or otherwise dispose of the property until the death of the parent or whoever you're giving that property to, whether it be a spouse. Well, obviously, if your spouse, it doesn't matter, but most likely it operates better or best if it's a child or a cousin or a friend or something of that nature. Because obviously, if it's a spouse, it's going to be automatic on your death that your estate, unless you do as tenants in common, otherwise, your property will pass automatically to the spouse. But in the case of a child, a friend, a girlfriend that you've been living with for life, or a boyfriend, and you would like to benefit that person, the best thing would be, because the estate is not something that is so huge that it would require the creation of a trust. It's just one property, and you're not likely to acquire any other property during your lifetime. Then the best thing would be to create a life estate on the deed and transfer the property. But life estate is not without its own complications, which you need to know. You need to understand the transaction before you just jump right into it. A life estate, as I said before, it gives your whoever, your child, partner, whoever it is, the ability to be entitled to the remaining estate in that property. As you know, in New York, we own property as freeholders, okay? Fee simple holders. Most estates are considered fee simple, right? So on the death of the grantor, the person who remains is going to take over that estate as a fee simple holder of that estate. Now, the reason why I said it's not free from its own complications is because, number one, if you change your mind, which do happen from time to time, sometimes people did do a life estate deed and then they decide, I do not want this to continue, and they want to change their mind and they want to do something differently. If you decide to change your mind and create and take back the property, you see you don't want a life estate anymore, that would be detrimental, because then what you got to hope for is that the beneficiary of the remainder estate would consent to allowing you to do that. Because if the beneficiary of the remainder estate is not consenting and they're like, listen, I really do not want to give you back the property, I don't want to sign any transfer documents to revert the interest back to you, then that's a problem. So I tell people, if you're going to do a life estate deed, please be very certain and very sure that the person that you're giving the remainder interest in the estate to, you're never going to change your mind about that and want to give it to someone else. I've seen that happen where a client gave her remainder estate to a nephew, and then later on when she fell out with the nephew, she wanted to change it. but then it was too late. She couldn't change it because the nephew was like, listen, I don't think so. I do not really want to sign any documents to revert this estate back to my aunt. But after a little bit of persuasion, she was able to get him to do it. But he was not happy about doing that. And he reluctantly signed the deed to send the property back to his aunt. Okay. Generally, like I said, you got to be very sure, because if people don't want to sign, then you have a problem in that you would have created a life estate and you would not have been able to revert it back if the person, the beneficiary, the person you would like to benefit, does not want to sign any documents. You've got to keep the documents. You've got to keep it in your own, you got to keep it the way it is, because they would not want to they wouldn't want to do that for you. Okay. But if you know that the person you're sending it to have no problem, and if you change your mind, they'll be willing to sign documents to revert the property back to you, then you can be inconsistent. You can change your mind later on, and you can go back to the intended beneficiary and say, like, listen, I changed my mind. I would like to cancel this life estate and revert this deed back to myself. And the beneficiary, if they're a cooperative person, they'll be like, okay, no problem. I will sign it and give it back to you. And then you can choose to give it to a different person, or you can choose to leave it as is and then make a will or whatever it is you're deciding to do. But generally, when there's just one single real estate, unless the real estate, let's say it's worth millions of dollars, because a single real estate could be worth $4 or $5 million or more, depending on the size of the property. Some people have multi units in it. So it has like 20 units or 30 units in one building, an apartment building. In that case, then a trust is warranted. But if it's like a single family house that you own that is only worth $500,000 or less, then there's no point in creating a trust, because you would have spent more money to create that trust than it would have cost anyway to maybe create a life estate in the property, because the life estate in the property is not worth that much. Okay. So you can easily say, well, because the life estate is not going to be worth, it's not going to cost you $5,000 to create a deed and have it filed with the city or the municipality in which you live, then you can just go ahead and create a life estate deed. It will be cost efficient for you. You wouldn't spend a whole lot of money on that. All you'll be paying is the cost to prepare the transfer documents and the filing fees. And that will significantly reduce the cost to you, bearing in mind the caveats that I mentioned earlier about if you transfer that, you put somebody to you enjoy the remainder interest, and then you change your mind eventually. The problem is getting that person to sign the documents to revert the deed back to you if you should change your mind. So be very sure and know what you're doing if you decide that you're going to take a life estate deed and put the property in your beneficiary's name and your name. Okay. Now, again, like I said, cost effectiveness. That's one of the reasons people will hop up for that option. And then the value of the estate is not that high. So it's not worth creating a trust. Okay, because the trust situation is when you have a larger estate. Your estate is $1 million or more, and you would like to make sure that whoever you're benefiting, and you have more than one beneficiaries, number two, and you would like to ensure that the people that you're benefiting will get the most out of your asset without having to probate a will, without having to go to the court, without having to take care of any of that. And the number one mistake I see that is being made with these trusts, because I've seen people come to me with trusts they said other attorneys created, and the number one mistake I see is that they never transfer the property to the trustee. And if you don't transfer the property to the trustee, guess what? On the death of that testator, you will end up at the court because no one registered the trust. The trust has to be registered, and you have to transfer over the documents, transfer over the properties to the trustee. The whole purpose of the trust is that it comes out, it leaves the hands of the testator, and it goes into the trust so that the trustees are the ones who are then going to manage that estate for you, and you don't have anything to do with it. Or the testator, him or herself, could be the trustee, one of the trustees, and then they can be successor trustees. Most of the trusts, you create successor trustees so that you personally don't have to be the one to keep, if when something happens to the main trustee, you don't have to, nobody has to appoint a new trustee. There's a successor trustee under the trust who's going to take over the property and to keep managing it. But the distinction here between the life estate and the trust is that, one, it goes into both parties' name. On the life estate, the property goes to both parties' name, right? With the remainder interest to your beneficiary, with the current life estate in the testator, or whoever is settling whoever the grantor, whoever is creating the life estate, right? And then whatever remains goes to your beneficiary on your debt. So that means your beneficiary could never sell the home without a debt certificate. Whenever the beneficiary is ready to sell that house, they'll have to produce to the purchaser or the title company who is creating the title report or the title insurance. They'll have to ensure that there's a valid debt certificate showing that the grantor has passed. Once the grantor is dead, then it's the only time that your beneficiary who inherited the remainder estate will be able to sell, dispose of, transfer, do whatever they want to do with the remainder estate. So you got to bear that in mind with the life estate deed. So the situation that I mentioned earlier, with the man who is now deceased, with his son, where the son attempted to sell the house with the father being alive and still being there. He actually tried to evict his father first and then to sell the property. But you can avoid these things by ensuring that if you do want to benefit a child, whoever, on your debt, that you create a life estate. Do not trust to put your property in your children's hands while you are alive. As I said, you made them, but you didn't make their mind. You only made the physical body. So be careful of, if you want to benefit your children, be careful and make sure either you do a trust or you create a life estate so you don't have to worry about it afterwards. You understand? So again, in the case of a life estate, it wouldn't be advisable to do a life estate. Say, for instance, if you're single and you would like to get married, okay? You already own your property and you meet someone and you would like to marry that person. Do not create a remainder estate so that on your debt, the property will pass to somebody else, okay? That's not advisable. The trust is more advisable in that case. If you have pre-acquired property and then you choose to get married, right? And you want to avoid your spouse being able to get their hands on the property, I would say create a trust prior to getting married so that that spouse will be never, ever be able to touch your asset because it's in a trust. It's already in a trust. And whoever is supposed to be the beneficiaries under that trust, those are the parties who are going to actually benefit from that trust on your debt, right? But it doesn't apply where you have a spouse and you want to create a remainder interest to somebody. Your spouse could easily go to court and contest that life estate and say, well, I'm entitled to something from the remainder estate because I contributed towards the mortgage. I spent $20,000 on the roof. I put new windows in the house. Then the spouse could maintain a cause of action or causes of actions against your assets and against your beneficiary on your debt. So it's never advisable to do a life estate when you're marrying to someone and you intend to live on that property with that spouse, right? The best thing to do is to create a trust in that case. If you have pre-acquired property and you're thinking about getting married, create that trust first, then get married. Okay, because even if the line doesn't get blurred in terms of what asset you use on the property, let's say for argument's sake the line does not get blurred, you never took marital assets to invest in that property and you kept that property as separate. If you're no longer there to defend any action, guess what? Your beneficiary has a right, and your beneficiary, your wife who survives you, could go to the court anyway and still file an action against the remainder beneficiary. You're no longer there to say, well, it's true or it's not. And that will put your beneficiary to cause to have to go to court and to defend it and to say, well, this never happened. There was no situation where there was no situation where the spouse was actually putting money into the property, investing into it, but you're no longer there to defend. And your beneficiary, chances are, wouldn't know. You understand? And then it's going to be a long process where your beneficiary has to get bank statements, records, and all sorts of things to establish to the court that your surviving spouse never contributed to the asset, never did anything to the house. But it makes sense to avoid that, right? So your beneficiary wouldn't be put to great cost while you're no longer here. So in that case where you marry somebody after you acquire that asset, a trust is much more effective in protecting that asset, right? And in the case of the life estate, that's more appropriate where you maybe have just one child and it's a small estate and there's not much. Is maybe it has equity of up to $500,000, even up to $1 million in assets. Still not a lot to be thinking about creating a trust for one child, unless you have grandchildren also you would like to benefit, or you have a surviving spouse who you would like to benefit, and that spouse was not a person who contributed towards that asset or assist you in acquiring that asset. But you would like that spouse to remain in that property and to live there until that spouse dies. So in that case, yes, I will say go ahead and create a trust. Otherwise, you just have one child, one asset, doesn't have much value. You have a mortgage to pay off. Still, I would say go ahead and make a life estate deed so that you'll enjoy that property for the rest of your life. And after that, your surviving beneficiary can take that property and do whatever it is that they choose to do with it. And there will be no problem. Okay. So this is what my thoughts are. And I thought I would share this with you. Again, guys, this program is brought to you by Washington Law Firm. We're located at 455 Utica Avenue in Brooklyn, New York. And I encourage you guys to continue to share this live. Share it with all your friends, all your family, your neighbors, whoever. Share this live. And I want to thank all of you who come here from week to week to watch this program. I thank you so much for all of your support. For those of you who've been referring our firm to your friends, your family, whoever, thank you so much. We get so many referrals, and people often tell us, oh, this person referred me or that person. Sometimes I don't readily know who it is, but whoever you are that has been referring us to your friends, your family, I thank you. And we're grateful for all of your love and support, guys. And I know that we're in the Christmas season. Many of you are celebrating. So I want to take this time out to wish you guys a Merry Christmas. And I know that 2025 is going to be a great year for all of us. And I'm looking forward to continued support from every single one of you guys. Thank you so much again for all the support. And for those of you looking, the number, if you need to call the office, the number is right on the screen. It's 718-877-3100. Continue to share the link. I encourage you. Don't stop sharing. Like and share. That like button means a lot, because it means that the algorithm is going to pick up the video and it's going to be able to reach so many more people once you click on the like button and click the share button, guys. Okay, I hope that today's edition was enlightening for some of you. If you're wondering, should you do a life estate? What is a life estate? Should you do a trust? What is a trust? And I have done prior videos explaining what a trust is. So today I focused on the life estate. And I hope it was informative to those of you who did not know what a life estate is. I trust that after today, you understand the life estate and you'll be able to do it. And also note, guys, that if you're buying a property, you can also explore the possibility if the mortgage company would allow you to purchase your property on a life estate. The bank might not agree. So if the bank doesn't agree, then you just buy the property with your name on a bargain and sale deed. And then afterwards, you can change it over to a life estate deed at any time. I've just recently witnessed an elderly woman purchasing a property with the help of her son and her brother. And I think in that case, it would have been very appropriate for her to either create a life estate afterwards or at some point. The reason being, her son contributed and he was assisting her in coming up with the deposit, the security deposit, or the down payment, we call it, for the property. So I'm thinking maybe at some point she's going to either create a will or she's going to create a life estate to benefit her son in the event of anything happening to her, because she looks like she's closer to retirement, but for some reason she's only now purchasing a property. Guys, not everybody do things at the same times in life. Some people take longer than others, and that's very okay. It's just that you just have to know what you're doing and to get things right. As long as you get it right so that you will protect your family's interest, your interest, everybody's interest. That is the main thing. And one of the reasons why protecting your assets is so important. I've seen too many cases where people left assets and some spouse or somebody who didn't even know the struggles or understood the struggles came into the picture and tried to disinherit everybody else from what they might have been entitled to. I've seen a very sad situation happen where an elderly woman, she was at the time in the 70s, and she got married to a much younger gentleman from Haiti. That gentleman married that woman for a green card. The family knew it very well. Everyone knew it very well that he was marrying that lady for a green card. And on the death of that woman, do you know, even though that gentleman was aware that it wasn't a legitimate marriage, it was for the purposes of her helping him. And the lady probably needed some help too, because he was helping her, and he was mostly driving her car. I mean, I got this information secondhand from one of the ladies' beneficiaries on her estate, said that the husband was, assisting her with errands, going to the supermarket, making sure that she had everything at the home. And do you know, at the death of that woman, that man decided to go and hire an attorney and to fight the family for his elective share in the lady's asset, because she died. I think, I'm trying to remember if she had a will or she died intestate. Either way, if she died intestate, the law permits the husband to get 50% of any assets that she left behind. And that man tied up that entire estate because he meant that he must get what he thought he was entitled to, even though he had nothing to do with that lady's assets, was nowhere around when she purchased the house, was nowhere around when she was working in or during her working years, but rather he met her like maybe a year before she died. And he was able to go to the court and to fight that lady's family for what he thought he was entitled to. So guys, be very careful, protect your assets, and just note whether or not you're marrying for love or just business, protect yourself, protect your asset, protect your family. Make sure that your family are taken care of should something happen to you. Make sure that you either create that life estate interest upfront or create a trust. Do not take chances, guys. Again, thank you so much for joining me today for the Law and You. And I do hope you enjoy the rest of your weekend. And I do also hope that I'll see you again next week, Saturday at 4 p.m. so that we can discuss the law and you, issues affecting people every day as it relates to the law. That's what this show about. Thank you so much, guys. Again, if you need legal advice, consultation, my number is right on the screen, 718-877-3100. Thank you so much, guys. Enjoy the rest of your weekend, and I'll see you next Saturday.